30 seconds.
Do you want this door closed or do you want to?
Yeah.
Thanks.
Welcome to the Washington Legal Foundation's 28th Annual Supreme Court Briefing at the end of the term. My name is Glenn Lammy. I'm Chief Counsel of the Foundation's Legal Studies Division. I want to welcome all of you who have joined us here in person and also those of you who are online as well. The Foundation this term, I think, had one of its more outstanding times in the court. I think it's very appropriate that in our 40th year we were as successful as we were this term. We filed in merits briefs, amicus briefs, in 10 decided cases that were, which were 8-2, and then 9-2, and then one carried over the Jennings versus Rodriguez case, which there was not a decision in. We were especially proud of the decision in the Ziegler versus Abbasi case. We represented 5 former attorneys general and 2 former FBI directors in that case. We also supported the cert petitions in 6 of the cases in which we filed on the merits briefs, prevailed in 5 of those cases. We were also cited by Justice Kennedy in his majority opinion in the CalPERS versus ANZ Securities case, so that's something to certainly be proud of. And especially most of the issues that were decided on this year were ones that we've been trying to foment pro-free enterprise thinking in the judiciary throughout a good part of our history. So we're especially proud that cases like BMS and Kokesh and others came down the way that they did, mostly unanimously, if not almost unanimously. And we had a very interesting diversity of ideological backgrounds in the justices that wrote opinions in the cases that we filed briefs in. Justice Ginsburg wrote 2 opinions in 2 of our cases, the Baker case and the BNSF case. Justice Kennedy, Justice Alito, Justice Sotomayor wrote the Kokesh decision. So I think it's fair to say that our perspective on things as free enterprise advocates have been taking on significant weight over time, and we finally got some victories in a lot of these issues that we've for years been doing papers on and briefs and blog posts. So I think it was an excellent term. I want to introduce the speakers that are going to be speaking in the order in which they're going to present, and then I will get out of the way and they will go forward with their presentations. Leading off is Andrew Tuomello, who's the co-partner in charge of the Washington, D.C. office of Gibson, Dunn & Crutcher. He's also co-chair of the firm's Sports Law Practice Group and a member of the Class Actions Practice Group and the Appellate and Constitutional Law Practice Group. He successfully argued the BNSF versus Terrell case before the court this term. Going second will be John Thorne, who's a partner with Kellogg, Hanson, Todd, Frederick PLLC from 2000 to 2012. Mr. Thorne was Senior Vice President and Deputy General Counsel at Verizon Communications, where he headed Verizon's competition and intellectual property practice groups. Finishing up for us today will be Adam Unikowski, who's a partner in the litigation department and a member of the Appellate and Supreme Court Communications and Technology Litigation Practices in the Washington, D.C. office of Jenner & Block. He was counsel of record in 3 cases before the court this term, each of which were decided unanimously in his client's favor: Kokesh versus SEC, Honeycutt versus U.S., and Howell versus Howell. For those of you who are joining us online, there is a Q&A function next to the screen that you're watching on. You're welcome to send in questions anytime that you'd like to. They are only seen by us here in the office, so they're private questions. We will be providing those to the speakers at the end of the program. Drew, if you could get us started.
Sure. Well, thank you very much, and thank you for having me. I'm going to take the personal jurisdiction cases and a couple of the other civil cases that the court decided this term. It was a very good year for getting clear, predictable jurisdictional lines from the court. There was a major case on general jurisdiction and a major case on specific jurisdiction coming out of the Montana Supreme Court and the Supreme Court of California, respectively. So coming off the Supreme Court's decision in 2014 in Daimler, there was a lot of optimism, I think, among corporate defendants at least, that expansive capacious, robust general jurisdiction had finally been limited truly to places where a corporation had its principal place of business or was incorporated. We began to see a number of different theories that tried to circumvent or evade Daimler's apparently clear holding. And so some cases took issue with the fact that Daimler seemed to involve transnational facts and a foreign or German company, and that seemed to be relevant. Others focused on the fact that the claim in the Daimler case seemed to involve events entirely overseas. And so in the case that we handled, BNSF versus Tyrell, all those distinctions were at issue. The suit was brought by two former railroad workers against BNSF, which does a lot of business in Montana, but it's not incorporated there, and it doesn't have its principal place of business there. The claims had no connection to Montana. The plaintiffs didn't live in Montana. They had never worked in Montana. They had never been in Montana. And they filed a suit there essentially alleging that BNSF did so much systematic and continuous business that it was essentially at home, and that Daimler's at-home rule didn't apply because BNSF, unlike Daimler, was a domestic corporation, and that railroads are different. They have a permanent corporate infrastructure in a state. They have, literally have property that runs from state line to state line. So that is the issue that went up, was whether a corporation could be subject to general personal jurisdiction in a state where it is not at home and where it doesn't have its principal place of business. And the court, 8-1, held that it cannot be subject to general personal jurisdiction there. Justice Ginsburg wrote the opinion for the majority, and Justice Sotomayor dissented. I think the case is, I like to think of it as, our hope for the case was to be, to make the squib number 2 in the civil procedure book after the discussion of Daimler. I think it really closes the door, I think, to any kind of creative arguments that Daimler doesn't mean what it says, and that general jurisdiction, true all-purpose dispute line general jurisdiction, will only be available in one of two places. There is the reservation in both Daimler and in BNSF about exceptional circumstances, but I think those have really been confined. The case everyone keeps citing is the Perkins wartime case, where the defendant seized operations in the Philippines and the president of the Canadian was in Ohio, and all the activities seem to be run out of Ohio as kind of the one example of an exceptional case. So general jurisdiction does seem to be relatively confined. I think sort of the next frontier on general jurisdiction is almost certain to be consent through business registration. That is a theory that was reserved by the Montana Supreme Court in the BNSF case, but it is one that has received a lot of attention. The theory would be that by registering to do business in the state, a company has implicitly consented to general all-purpose jurisdiction in the state. The Second Circuit has, I think, the best treatment of this issue in a case called Brown versus Lockheed Martin, where they were construing a Connecticut registration statute and pointed out all of the difficult constitutional issues that would arise if you interpreted a business registration statute as consenting to general jurisdiction as opposed to specific jurisdiction for activities that arise in the state. The reason I think it ultimately may get to the Supreme Court is because there is an old 1917 case, an insurance company of Ireland, that does pretty clearly seem to hold that registering to do business in the state is sufficient is consent to jurisdiction in that state. Didn't draw fine distinctions between general and specific jurisdiction, but I do think if if a court does not follow the guidance set forth in Daimler, and again in BNSF, the cases decided before international should deserve less weight today because they were based on outmoded or outdated ideas of jurisdiction. If you don't follow that admonition, then I do think citing Pennsylvania Fire at least is going to lead to some court somewhere saying that registration is enough. So I think that's, that may well be a fight that we have in the Montana Supreme Court as we go back, or may arise elsewhere. In the meantime, as these issues have percolated, as several state Supreme Courts, most notably Delaware, have reinterpreted their own state statutes as a matter of state law. Delaware used to interpret its own business registration statute as, in fact, affecting consent to general jurisdiction. In a 2016 case, they have revisited that, reevaluated the evolving constitutional doctrines, and reinterpreted their own view of Delaware business registration law to say it's only consent to cases that arise in the state or specific jurisdiction. And the same is true in Oregon and Missouri. So I think the trend is heading in the right way, but I think that is, for general jurisdiction, the open issue. Similarly, as there were attempts to circumvent the clear teaching of Daimler, there were efforts to push the definition of specific jurisdiction into more expansive areas, and that, of course, led to the Bristol-Myers Squibb decision. That was a 4-3 decision in the California Supreme Court that essentially held that California could exercise specific jurisdiction over the claims of non-residents who were not injured in California, didn't have their prescriptions of the relevant BMS drug Plavix written in California, but because there were other California plaintiffs who had filed suit and who were injured in California, on the sliding scale, it was sort of overall reasonable for the California court to take specific jurisdiction there. The Supreme Court again, 8-1, this time with Justice Alito writing a majority opinion, and again Justice Sotomayor in dissent rejected that as an overly expansive view of specific jurisdiction, and again required, I think, what had been fairly well established in the cases for the exercise of specific jurisdiction, some connection between the plaintiff, the injury, and the form. And here, for vast numbers of the individual plaintiffs who had sued, their suit had absolutely nothing to do with California. They were a little bit like the plaintiffs in the BNSF case. They had not been to California, their doctors weren't in California, they didn't take Plavix in California, they didn't seek marketing in California. So they really had zero connection, and the court said that is certainly not enough, even for specific jurisdiction. So I think with those two fairly, wins by a large margin on these issues, that we, finally should be seeing some predictability and stability in jurisdictional rules, and that all parties, and I think this is good for the civil justice system, will have just a better sense of where cases can be filed, where they should be filed, and all of this will deter, I think, a little bit of the development of magnet jurisdictions or rampant forum shopping, which I think can breed quite a bit of cynicism about the civil justice system. I think the follow-on questions that arise from Bristol-Myers Squibb really relate, I think, to federal court practice and federal court class action practice in particular. It is under the federal transfer statute, when you are trying to get a case as a defendant, when you're trying to get a case transferred, often you're trying to get litigation consolidated voluntarily without the MDL panel. You're looking to get it transferred under 28 U.S.C. 1404, which requires that you be trying to transfer the case to a district in which the suit originally could have been brought. I think after Bristol-Myers Squibb, it's going to be very difficult to get what I would say voluntary transfers or 1404A transfers to courts outside the state of the defendant's principal place of business. The panel on multi-district litigation, has traditionally said, look, we're not going to form, in the last 10 years has made a very concerted effort to say to litigants in complex cases, we are not going to centralize and form an MDL until you, the parties seeking centralization, work through the 1404A process. And I think that is going to become much more difficult for defendants to do outside their home districts. So I think that's an area to watch. And in particular, whether the MDL panel becomes a little more open to centralizing cases in the first instance without so much heavy reliance on the first case on encouraging parties to use the 1404A transfer process. The other big jurisdictional case of the term was TC Heartland, and that involved interpretation of the patent venue statute. There is a special patent venue statute as compared to the general venue statute. There are about 200 special venue statutes. And the special patent venue statute said the venue was proper either where the defendant resides, which had been interpreted by the Supreme Court to mean the defendant's place of incorporation, or where the defendant has committed acts of infringement or has a regular and established place of business. That's what the special patent venue statute said. In 1990, Congress amended the general venue provision to define residence for venue purposes as essentially any place where a corporation could be subject to personal jurisdiction. So if you took the definition of residency in the general venue statute and you imposed it on the language of the special patent venue statute, then essentially you could sue any place that you could establish specific jurisdiction. And the court held in TC Heartland unanimously that the definition in the general venue statute did not affect the scope of venue provided for in the special patent venue statute. And the most immediate impact of this, not mentioned anywhere in the decision, but most immediate impact on this is most likely to be a shift away from the concentration of patent suits in the Eastern District of Texas. This really didn't come up too much, an argument, but was certainly featured in the amicus briefs in sort of vivid detail about how the sort of a metropolis has formed around the courthouse in the Eastern District of Texas with new hotels and restaurants and so forth, because of all the patent litigation going on there. Raises a host of interesting questions. With respect to all the patent cases that are pending, does this venue rule apply to currently pending cases? What if you waived your venue objection? Can you evade any argument about waiver because it's a brand new Supreme Court case? Apart from the first prong, where a defendant is incorporated, what does the second prong mean? Where the defendant has committed acts of infringement and has a regular and established place of business? That's probably going to get quite a bit of litigation. But in the, I think from 30,000 feet, you put all of these cases together. I think they all turned on both statutory analysis and well-settled due process principles. But from a 30,000-foot level, these three decisions in both the patent and non-patent area really do establish much clearer, cleaner, predictable jurisdictional rules, and as an incidental benefit, I think make it much, much more difficult for plaintiffs in both patent and non-patent cases to engage in what I believe to be a kind of unhealthy form shopping. So the other two cases that I've met just briefly, there was an arbitration case, Kindred Nursing. Kentucky had a special rule saying that if you are appointing in a power of attorney, you're handing over power of attorney to someone, you want that person to be able to enter into arbitration agreements, it has to be specifically noted. And so there was no similar requirement for anything else. The court has been very clear over the years that state rules that single out or subject arbitration to disfavored treatment are effectively prohibited, preempted by the Federal Arbitration Act. This was again, a unanimous and very short decision holding the Kentucky provision preempted. And then the final case that I will address is the Goodyear sanctions case. And Goodyear raised, it was a fascinating question. This is a products liability suit against Goodyear. The Goodyear and the plaintiffs had resolved the case, and then it came to light after settlement that Goodyear had not produced some internal testing documents that I think it's fair to say the plaintiff would have been very, very interested in. And the plaintiffs were fashioned into court, and the district court awarded the entirety of the legal fees that the plaintiff had expended in litigating the case as a sanction. And so the case come up to the court, and again, this was a unanimous opinion this time, written by Justice Kagan, saying that, look, there has to be, a district court in exercising its sanctioning authority can't simply dish out something that is unrelated to compensation, to making the plaintiff whole. And if there had to be some analysis, some effort to tailor the sanction or the remedy to the misconduct. And so and I think the faulting of the district court in this particular case is that that effort hadn't been done. There'd been no effort to engage on how much of the trial or how much of the discovery or how much extra work had to have been done, but because of the concealment of the internal testing results. And the court, I think, left the door open expressly to say, look, there are certainly circumstances where you, as a party who has confronted such misconduct, there's certainly circumstances where you could ask for and receive the sum total, the full total, 100% of your litigation fees, but it would have to be very clear that the proceeding, all of the proceeding, was a but-for cause of the concealment or the misconduct. So why don't I stop there? I've got, maybe in the questions time, I'll say a little bit about a 10B case that we'll be handling next term on whether the court should expand the private right of action under Section 10B. I will say, we were just asked in closing if we had any anecdotes based on our experience at the podium with Justice Gorsuch, and although this was covered at the time in the BNSF case, with Justice Gorsuch being the, from the West, the chief was asking Respondents' Counsel, really how can railroads be different? Don't trucking companies also kind of, go through crisscross the state? And she said, what is it? Is it I-95 or I-90 that's across Montana? And then Justice Gorsuch jumped in and said, no, it's I-80 in Montana. And he seemed pretty definitive about it. And I was seated at the time, and I kind of looked over and could see that there was maybe an inkling of doubt that that was correct. And then they summoned for an atlas of interstates in the U.S. And so it was Justice Gorsuch and Sotomayor and Breyer kind of pouring over this atlas, and then Justice Kagan and Alito on the other side got into the act, and they had an atlas coming in, and I can't be certain about this, but I thought I saw Justice Sotomayor say, "Ask Clarence," to summon his, his knowledge of the interstate roadways, but. it turned out that, in fact, the chief had been right. It was I-90. It was not I-80, as Justice Gorsuch said, and he quickly corrected himself when he found that. But it was one of the lighter moments in, in an otherwise serious, if not arcane, argument about personal jurisdiction. So I'll stop there. Thank you.
Glenn, thank you for the introduction, and thanks to the Washington Legal Foundation for the invitation to be here. I'm going to start with an unscripted plug. I've been working with the Washington Legal Foundation for, I think, over 2 decades, and it is a uniquely effective organization. So to my friends in the audience, consider getting involved if you aren't. We were asked to come up with something about Justice Gorsuch, and he was a partner at my law firm and practiced there for 10 years. And most of the time that he was at the firm, I was at a client. But there was one case where he and I wrote the briefs together. He did most of the writing of the briefs, and I argued the case in the Ninth Circuit. And his briefs had such moral clarity and force that even though I was standing at the podium, the briefs were what carried through. Opposing counsel got up and responded to what we were saying, and Judge Noonan from the Ninth Circuit leaned over and said, if your client did what Bell Atlantic says it did, your client is a scoundrel. I had a good feeling at that point. I'm glad that Justice Gorsuch is still very confident in himself, too. It was a good prior story. So I'm going to talk very briefly about the patent cases and one related Federal Circuit case in the Supreme Court this past term. There were 7 cases. You want to do the statistics. The Federal Circuit gurus usually don't like to do the statistics. But 7 cases, and all 6 patent cases, the Federal Circuit was reversed. The one First Amendment trademark case, the case about the dance rock band called the Slants, they were affirmed. Of the 6 patent reversals, 4 were unanimous. One of the opinions drew a single dissenter, the other drew sort of a half dissent, so it's pretty lopsided. Maybe by the time we get to questions, we'll get to talk for a minute about 3 new cases for next term, 3 new patent cases that are exciting. But if you ask yourself, why is the Federal Circuit doing, at least of the cases the court takes, is not a random sample, of course. These are selected, these are singled out for different reasons. But why is the Federal Circuit losing? And you compare its statistics, for example, I think the Ninth Circuit is the only other circuit with a large enough sample size to have such a reversal rate. But why are they losing? This term it was reading the statute, a constitutional limit, and a deep principle of common law going back to the 17th century. So T.C. Heartland was one of the cool cases, but Drew's already talked about that, so I won't say anything else except that I would not count out the Eastern District of Texas yet. The other half of the special venue statute for patents, a regular and established place of business, is yet to be interpreted. And companies right now are thinking to themselves, do we keep that office in Plano? Do we move it across the highway to Richardson? Do we let those employees work from home if they work in the wrong county? I mean, people are actually making, now it matters if you have a regular established place of business, and people are making decisions about whether to stay there. So aside from that case, there are little themes to these things. Justice Sotomayor decided two cases, or wrote 2 decisions this term. I'm applying the Patent Act to multi-component products. I want to pause there just enough to say this is a bonus question for those in the audience. Ask yourself, why are multi-component products important? She had 2 of them, 2 cases about that. First was Samsung against Apple. And by the way, it's not enough to say Apple against Samsung or Samsung against Apple because there are so many cases with that name. But this was the one involving a design patent. And Section 289 of the patent statute says that it's unlawful to manufacture or sell, here's the important text, an article of manufacture to which a patentable design has been applied. And so the question is, what's an article of manufacture? And the reason that matters is because you get the total profit, all the profit from the article of manufacture that has the infringing design upon it. So 10 years ago, Apple introduced a glowing rectangle with colored grid of icons on it, sort of rounded edges, and they had a lot of design patents. Samsung was found to infringe one and was held liable for $399 million. Its total profits on the sales of the Samsung design patent infringing smartphones. And the question for Justice Sotomayor's opinion was, what's the article of manufacture? The design was on the front. It wasn't the whole thing. Can an article of manufacture ever be less than the thing sold to the end user? And in sort of a disparaging way, she quoted a line of the Federal Circuit's decision, innards don't matter, it's what's sold to the customer that matters. And she said, well, that's not how I read the text. And she said, an article is just a particular thing. Manufacture means taking raw material, converting it into something useful. A thing that's converted into something useful, that could be something less than the whole that's sold to the customer. And so she wrote, and there was no separate opinion. It was very short, 8 pages in the slip opinion format, very short opinion saying, just read the text. A design patent can apply to an article of manufacture that's less than the whole thing sold to the customer, sent back for calculating what the total profits would be on the part of the Samsung phone to which the design was affixed. Second multi-component case that she wrote, Life Technologies against Promega. This is section 271F1. You all know what that means. That's the prohibition in the patent statute that says you may not supply from the United States all or a substantial portion of the components of a patented invention to be recombined abroad. So suppose you were an infringing American manufacturer and you wanted to sell your infringing product outside the US, you might try to evade 271F by selling the parts. And they just be like IKEA, send the parts and they'd be reassembled elsewhere. The statute says if you sell all the parts or a substantial portion of the components, you're found liable. And the Federal Circuit said, well, what if one of the parts is really, really important? You know, the other parts, maybe all parts are sort of created equal. This one's more equal. This is a really important part, and that's being supplied by the U.S. And so the Federal Circuit left open the possibility that selling one of 5 components of a genetic testing kit could be important enough to warrant liability. And in this opinion, Justice Sotomayor was a little bit like teachers I had anyway, with slow students. We're going to start with the text, and we're going to look at the context and the structure. And she actually added a little paragraph at the end of her opinion on legislative history just to draw the necessary concurrences that we don't subscribe to legislative history. But she wrote that this is actually a remarkable opinion. You look at the text, it's a better read to think a substantial portion of the components is a quantitative test, not a qualitative one. So how many of the components fits better with the language and the structure and the context than how important are the components. And what's most amazing is she takes the next step and she says, we're going to make the statute administrable to juries and courts. And if we count components, we're going to get a more reliable result than if we grade them qualitatively by importance. And so there's another opinion just like this. Justice Scalia in the Trinco case from a decade ago. In the antitrust context, it's a little bit of a plastic statute. You can expand the universe of what's condemned or contracted. Justice Scalia said, you know, if we have trouble identifying the conduct that's to be condemned, that's a reason not to do it that way. The administrability matters, and she wrote that. She wrote that here, that it's important in choosing between a quantitative or a qualitative, or maybe both qualitative and quantitative tests, it should be administrable. And then she goes on to reach the further result, and then she stops. Further result that if it's just one component of a multi-component, in this case 5-component kit, it's never enough. It's never a substantial part to have just one part, substantial part of the components. Then Justice Alito wrote a couple of opinions. His theme was the Constitution. There's a very old doctrine called laches that common law equity courts would use to say that your case is too late. I can't do you equity anymore. You've waited too long to bring it. Circumstances change. It's unfair in different ways. The SCA hygiene case considered whether laches could be a defense to money damages, not equitable relief, money damages in a patent case. And the quirky history of the patent statute for literally a couple of centuries had been that Congress was letting equity courts, in patent cases, equity courts award money damages. And so these equity courts were considering laches as a defense. You waited too long, and I could have awarded you money, but I'm not gonna because you waited too long. So that peculiar history was the backdrop. But in the Patent Act, Congress passed a statute of limitations. You can look backwards 6 years for money damages. And 2 terms prior, in a case called Petrella, the court had said in copyright, by the way, there's another theme, not just this term, but every term. What are they doing over there in copyright land? And it's always good to look at other areas of the law and then say, well, should we do that in patents too? In Petrella for copyrights, the same question came up. You've got a statute of limitations, you've got a laches defense. Can they coexist? And Congress in Petrella, Justice Ginsburg wrote, no, they can't. That where Congress has specified the time period, judges don't make special time periods through laches. And Justice Alito said the same here. Now, he said this is not just analogy to copyright, it's an application of separation of powers. Applying laches within a limitations period specified by Congress would give judges a legislative overriding role that is beyond the judiciary's power. So, well, separation of powers, no laches. We look only and by the way, that's a big problem in the patent world because in general, the kinds of cases that T.C. Heartland didn't talk about but affected in East Texas, those are cases where somebody is just asserting the patent. They don't have an actual business interest other than the monetization of the patents. In those cases, they tend to be very old, end-of-life patents. Most of them way over 15 years old. A lot of them expired already. You can still sue for back damages on an expired patent. But unlike regular company patent litigation in the troll or non-practicing entity space, very old patents. And so laches is a problem. But that's not a defense anymore. The other case that Justice Alito decided, and I'll only say a word about it, its name is Mattel against Lee. It involves the band The Slants. It's a trademark case, not a patent case. Under the Lanham Act, the Patent Office is not supposed, Patent and Trademark Office is not supposed to register a trademark that may disparage or bring into contempt or disrepute any persons living or dead. And Justice Alito wrote for the court that provision violates the free speech clause of the First Amendment. Speech may not be banned on the ground that it expresses ideas that offend. And as one of my favorite news sources, The Onion, reported afterward, this is great news for the Seattle Seahawks. So there was another justice, in addition to T.C. Harlan, Justice Thomas had another decision, Sandoz against Amgen. It's about the Biologics Price Competition Innovation Act. The bottom line was the Federal Circuit misread the statute, but it was a fairly gentle decision. And the last decision I want to talk about, and then I'll sit down so I don't overrun my time here, was by the Chief Justice. And this was Impression Products against Lexmark. And I could give you I'll give you a little bit of it. Lexmark is a printer company. They sell a plastic box with electronics in it, and it needs toner cartridges to keep printing. And most of the money comes out of selling replacement toner cartridges. And so it turns out there's a fairly vibrant aftermarket in replacement toner cartridges not made by Lexmark. Lexmark tried to control this aftermarket through its patents by limiting how they could be how the cartridges could be reused. So the basic doctrine in patent law that says that if you sell something, that's patented. You can't enforce restrictions. It's called exhaustion. There were two. I'll talk about this more in a couple minutes, Glenn. But there were two exceptions to exhaustion that the Federal Circuit had recognized. And I do have to just tell this one story. I'm gonna wrap up here. When one of the new judges on the Federal Circuit, Richard Toronto, was having his investiture, this is in front of the entire bank of the Federal Circuit judges, a large audience of his friends, the Chief Justice came over to do the honors and made remarks about what a great advocate Richard Toronto had been as a lawyer practicing in the Supreme Court and a lawyer in the Solicitor General's office before that, and how the very first time that the chief had to reverse a Judge Toronto decision, he was going to feel a twinge. I'm sure he felt a twinge here. It was Judge Toronto's decision for the en banc Federal Circuit Court that the chief was reversing. But the cool thing, I encourage anybody that's interested in structure of government or even a little interested in patent law to read this decision. The interesting thing is partially the respect the chief shows for the Federal Circuit in reaching the wrong decision, unanimously the wrong decision. But also the basis. This is based on Lord Coke, 17th century. The common law lets people, once you've bought something, resell it. The original seller can't continue to control the goods, except through contract. Contract and other things can sometimes bind the immediate parties, but the patent laws have been construed, and here with extra vigor. The patent laws don't let you restrain further alienation of goods. So you would think, but I won't quote the whole thing, but the chief closes by saying that allowing patent rights to stick remora-like to an item as it flows through the market would violate the principle against restraints and alienation. It's a very definitive decision, and yet I'm expecting much more litigation in this space because the world of software doesn't think they actually ever sell you anything. They merely license it to you. And the world of software is taking the position now that they have not sold you a product. So one of the examples the chief uses in his decision is cars. He said, imagine what chaos you'd have if you went to a car repair shop and had new parts, auto parts stuck into the car. He points out that there are thousands of different auto parts, maybe many of them patented. If the original maker of the auto part could now control whether you resold your car because they withheld some of the patent rights, that would be absurd. But cars have software in them. And the people that are selling software think they have a right, because they don't sell you the software, they merely license it, to control your car, control your toaster, control your smartphone. Anyway, this is a place to be fought more, despite the Supreme Court's apparent firmness on the subject. I will stop there, and thank you.
Thank you. I'm just going to speak for a few minutes about some of the securities cases from last term, the Kokesh case, the Salomon insider trading case, and the CalPERS case, which came out just a couple days ago. And if time permits, I'll also say a few words about the Murphy Oil case from next term, which addresses the enforceability of employee arbitration fees. So first, the Kokesh case, which is a case near and dear to my heart because I briefed and argued it for Mr. Kokesh. The case concerned the remedy known as disgorgement, and specifically whether there was a statute of limitations for disgorgement. So first, what is disgorgement? Well, the SEC has taken the position successfully that if it brings an enforcement action for securities fraud or other statutes administered by the SEC, and it finds the defendant liable, it can get a remedy known as disgorgement, which is basically a check that the defendant has to pay to the government for the profits or the proceeds that the defendant sustained from the illegal activity. So if you commit securities fraud and you collect a certain amount of money, you've got to pay to the government. If you violate the Foreign Corrupt Practices Act, which is another statute the SEC administers, and obtain contracts from bribing foreign officials, then the benefits of that have to be paid for the government. And other agencies have copied the SEC and also sought disgorgement, although the SEC is best known for it. Now, if you look in the security statutes and try to find the SEC's authority to bring disgorgement actions, you will not find it. It doesn't exist. the SEC started seeking disgorgements in the 1970s as an ancillary implied remedy to injunctions. The SEC's theory was that injunctions really aren't that useful unless there's some degree of backwards-looking liability to hold people accountable, and disgorgement is just the way to do it. And in the 70s, it was sort of a heady era for implied remedies, and the Second Circuit and other courts went along with this, and slowly but surely disgorgement has expanded and expanded. And now the SEC seeks disgorgement in almost every case and actually gets more money in disgorgement than in civil penalties, which are authorized by statute. And so disgorgement has become a powerful remedy indeed. So the question was whether a statute of limitations applied to disgorgement, and that turned on the application of a statute, 28 U.S.C. Section 2462, which is old. It was first enacted in almost identical form in 1839, I believe it was, that says that there's a 5-year limitations period for actions for, quote, penalties and forfeitures. And so the question boiled down to, is disgorgement a penalty or forfeiture or not? If disgorgement was a penalty or forfeiture, then there would be a limitations period. If it wasn't, then the government's position was there just was no limitations period at all. It could bring these disgorgement claims for action, for conduct going back forever. And in fact, in my case, my client had committed many of the illegal actions 14 years before the filing of the complaint, way before any 5-year statute of limitations. And the vast majority of the judgment against my client was for actions more than 5 years before the SEC filed its complaint. So the Supreme Court, per Justice Sotomayor, rather resoundingly rejected the SEC's position, holding unanimously that disgorgement is a penalty and therefore the limitations period applies. And I think it's useful to ask why the government lost this case, because I actually think the SEC might have been surprised that it lost, because it actually acquiesced to cert, which it very rarely does unless it thinks it's going to win the case. And in fact, the SEC had won this case in virtually every lower court. It had lost the case in this one Florida District Court opinion, affirmed in rather cursory fashion by the 11th Circuit, and every other court had found for the SEC on this, including every court within the Second Circuit where the SEC brings a lot of these securities claims. So why did the SEC lose? I think it's because if you take a step back, the SEC's position was, I don't want to say absurd, but sort of extreme. What the SEC was saying is that there's no statute of limitations at all, even though there's statutes of limitations for almost everything else in the entire world. So for instance, civil asset forfeiture, which is almost identical to disgorgement, there is a statute of limitations for that. Conversion claims brought by the government, there's a statute of limitations. Private securities fraud actions, everything else has statutes of limitations. So the question arises of why not this? And actually the government's answer was that it's because it's an implied remedy. They said that because there's no express statute of limitations, that means there just isn't one. Of course there's no express statute of limitations. It's because the remedy wasn't even enacted by Congress. So of course Congress wouldn't enact a statute of limitations for a remedy which it didn't enact in the first place. But the government actually embraced this and said, well, because there's no express statute of limitations, we can bring this claim going back forever. This, for a court already reluctant to approve implied remedies, this claim was not going to fly. And the other thing is that the government was really quite inconsistent in how it understood disgorgement, which I think is partly because disgorgement is an implied remedy with no historical pedigree. So for instance, we pointed out in our briefs that the government has taken the position that disgorgement is a penalty in other contexts when it benefits the government. So for instance, for bankruptcy filings, if disgorgement is a penalty, or is a forfeiture or a penalty, that means you can't discharge it in bankruptcy. And not surprisingly, the government has said in that context, well, of course it's a penalty and a forfeiture. Similarly, for taxes, you can't deduct penalties. And actually, the government's position was, for my client, disgorgement was a penalty for purposes of tax deductions, but also was not a penalty for purposes of the statute of limitations, which would maximize government revenues, but actually makes very little sense when you think about it. And the government adhered to this position in oral argument. It says, well, of course it could be a penalty for some reasons, not others. And I think the court was quite uncomfortable with that. And I think maybe the most obvious example of inconsistency was this question of whether the purpose of disgorgement was to compensate victims. That was the government's lead argument in its brief, that the reason disgorgement exists is to compensate victims, and so it's not a penalty. The problem is the government had repeatedly taken the position in lower courts that it wasn't primarily to compensate victims, to benefit the government. So it said victims didn't even have standing to challenge how disgorgement was awarded because the purpose wasn't to compensate victims. That was just an ancillary benefit in the discretion of the government if it wanted to give the money to victims. In fact, most notoriously, in a statute of limitations case several years ago, a litigant argued that the private statute of limitations applied for private securities actions because the purpose of disgorgement was to compensate the victims. And the SEC said, no, this is not about compensation. This is about deterrence and accountability. And the SEC won that case. And we were arguing that the statute about deterrence and accountability, the statute for penalties and forfeiture, should apply to disgorgement, and the government directly switched positions, saying, well, actually, this is really about compensating victims, and the court was not going along with that. So I think that beyond the effect of the decision itself, which will inhibit the SEC's enforcement actions, there's a footnote in the court's opinion that I think is going to get a little bit of attention, essentially indicating that the court was not deciding whether disgorgement even exists at all, which is sort of somewhat portentous because it's implying that the argument is out there that maybe there shouldn't be disgorgement at all. And maybe I can provide some perspective on that footnote, on how the case was litigated. So when I wrote my opening brief, the argument I would say I was particularly concerned about was this argument that the SEC had advanced in lower courts, which is that disgorgement is an equitable remedy. That's how it was framed. That's why it exists. And going back to 1830, equitable courts of equity didn't award penalties or forfeitures typically, and therefore disgorgement couldn't be a penalty or a forfeiture. So we had a bunch of responses to that, but I think our deepest response in our brief was that really disgorgement wasn't an equitable remedy as that term was understood before the merger of law and equity, and therefore an exception to the statute of limitations for equitable remedies wouldn't apply. Now, arguably, at least, the logical implication of this argument is that there shouldn't be disgorgement, period, because the whole basis for disgorgement is that it's an equitable remedy. But, that wasn't our argument. It was only about the statute of limitations. But I was a little bit nervous about the argument because that would be the logical, at least a potential logical implication. And so I got the government's brief, and it actually treated our argument as though it did not exist. There was no responses at all. I actually checked with the printer to see whether a portion of our brief had been cut off. It was the last section of our brief, because the government completely ignored this very lengthy discussion, but it had not been cut off. And at the oral argument, the justices were incredulous about this. There was numerous questions about why disgorgement exists. There's no authority for it. Is it really equitable? Most of them were directed to me, and I said, well, we certainly made that argument, and that's more for the government. And they were extremely puzzled by this. And then there's this opinion, which is as bad for the SEC as you can get, because there's this footnote basically encouraging lower court litigation, which I think may be successful, that disgorgement shouldn't exist. So I think that it'll be hard to wipe out disgorgement altogether, because at least there's some argument that Congress has ratified some version of disgorgement. There are some statutes that talk about disgorgement. But certainly the very extravagant theories of disgorgement that the SEC has advanced over the years are in danger. And for instance, most notably, in the Foreign Corrupt Practices Act context, there's very little argument that disgorgement is a genuinely equitable remedy. There's no discernible or ascertainable victims in these cases, so the payments are just deposited into the United States Treasury. So disgorgement there looks nothing like traditional restitutionary remedies at all. Nor is there any kind of historical pedigree, nor is there a congressional ratification argument, because most of these Foreign Corrupt Practices Act cases and in settlements, there are certainly no litigated cases that Congress could possibly have ratified. So, and in fact, I just add one other thing, the SEC has not sought these disgorgements for very long. I think they date back to the 2000s. So I think that hundreds of millions, probably billions of dollars the SEC has racked up in these disgorgement awards, if litigated in court, probably wouldn't stand. Now, Foreign Corrupt Practices Act defendants typically settle for many good business reasons, but eventually one won't settle, and this is going to be tried. And I would predict that the SEC may actually lose, and lose the ability to bring disgorgement, at least beyond at all in FCPA cases, which would have a huge effect on the SEC's enforcement program. So to turn to the other securities cases a bit more briefly, because I know we're running out of time. One was the Salmon case, which was, I guess, a loss for the defense bar. The court construed the scope of the insider trading statute, or the Rule 10b-5, rather broadly as applied to insider trading. The fact that case concerned tippee liability for securities fraud. So to just take a step back, when a tipper gives a tippee a tip of inside information, and the tippee trades on it, the tippee can be criminally charged with insider trading. Now, there's a case from the Second Circuit called Newman, which held that in that situation, the tippee doesn't commit a crime unless the tipper derives some kind of pecuniary benefit from the tip. In other words, if the tipper just gave a gift out of the goodness of the tipper's heart to the tippee, and the tippee traded on it, then the tippee couldn't be held liable criminally for the insider trading. And this was a rather dramatic ruling. It caused the U.S. attorney in New York to have to dramatically dismissed numerous indictments, and everyone was quite excited about this narrowing of insider trading liability. But then the same case came to the Ninth Circuit, and a district judge in New York, Judge Rakoff, who had famously disagreed with the Second Circuit's view on this, wound up on the panel in the Ninth Circuit, sitting by designation, and wrote an opinion approving the SEC's broad theory of insider trading liability, and his view was ultimately affirmed by the Ninth Circuit, by the Supreme Court, excuse me, and so the party generated by Newman ended. And so I actually think that this opinion doesn't really, imply that the court is going to be very solicitous of broad theories of insider trading or solicitous of the SEC's position. It was a somewhat inevitable decision in my view because it was almost resolved by this prior case called Dirks from about 30 years ago. The court in Dirks had actually said very clearly in its opinion as part of its holding that a gift of inside information could lead to liability for the tippee. And so the court just followed that holding, which has been the law of the land for decades. And the other thing is that the limitation to pecuniary benefit for the tipper didn't really make sense. As the court pointed out in Dirks, clearly if you yourself trade on inside information and give the money as a gift, there's liability there. It shouldn't be different if you just give the information. And that's what the court held. And I know we're running out of time, so I'll just say one very quick word about the other cases. The other case, CalPERS, there was a 5-4 case in which the ink is still dry. It came out on Monday. And that case had to do with whether the tolling rule of a case called American Pipe applied to statutes of repose. That's a bit of a mouthful, so let me just say a little bit more about that. So if you file a class action, and there's a statute of limitations that would bar your claim. There's a case called American Pipe that says that the statute of limitations is tolled if you later opt out and then file your own lawsuit. The theory being, if you're in the class of plaintiffs in a timely filed class action, then the statute, you can't be time barred if you later opt out and file your own suit. So that was a tolling rule applicable to statutes of limitations. And so the question in CalPERS was whether that tolling rule applies to a different type of statute called the statute of repose. And the difference is that statutes of limitations are statutes that run from when a claim accrues. In other words, when you have a claim, you have a certain amount of time to bring it. Statutes of repose cut off liability at a certain time, regardless of whether the plaintiff ever discovered the claim. So in this case, it had to do with misstatements in certain securities filings. There's a statute that says that 3 years after the filing, liability for misstatements is out of the picture completely, regardless of whether a claim ever accrued, if the plaintiff ever discovered it. So the court held that the tolling rule from American Pipe for limitations period does not apply to statutes of repose, which has the effect of cutting off a whole lot of lawsuits of objectors from class actions. So this was a 5-4 decision, and I think the message from this is that Justice Gorsuch is going to be very careful and hold plaintiffs' feet to the fire like the rest of his colleagues on the court, or at least the Republican appointees. There were some pretty good arguments for the plaintiffs here that the American Pipe rule should apply. The plaintiffs had some practical arguments that the proposed rule would just lead to all these useless protective filings by would-be objectors. The court didn't buy those arguments. It said that very clearly the statute of repose applies. It cuts off liability. The practical arguments that plaintiffs were raising couldn't avoid the plain text of the statute. And I think that bodes well for the defense bar going forward. So I'll stop now.
Thank you, gentlemen. We'll start out questions to give Drew an opportunity to talk about the Leidos case that he is involved with, and I would ask whether anything from the ANZ Securities case portends anything for you as a counsel in the Leidos case, the case that Washington Legal Foundation is going to be filing a brief in.
Well, I was just making some notes on that issue. So first, the Leidos case that will be heard next term presents the question whether an SEC disclosure requirement, of which there are thousands, but in this case it's SEC disclosure requirement 303, whether an SEC disclosure requirement can give rise to a duty to disclose that is actionable under Section 10b and Rule 10b-5. And the court has said many times that silence absent a duty to disclose is not actionable under 10b. And in this case, the securities filing at issue is absolutely silent about a particular topic, which is which was a government investigation that ultimately culminated in a lot of liability, but at the time, in the view of the company, is uncertain where it was going and whether they would even be an eventual target of it. So under traditional 10b-5 liability, a securities plaintiff would look at a filing or a statement in a press release and say, this statement was either false in its entirety or incomplete, a half-truth, incomplete by omission. And it's pretty well established that those two forms of liability fit within the terms of Rule 10b-5. Rule 10b-5 says that you cannot make any false statement of material fact or omit to state a material fact when necessary to make all the other statements made non-misleading. So it doesn't, by its own terms, cover pure omissions. And the Second Circuit in this case held that if a public company violates an SEC disclosure requirement by staying silent, even if that silence does not render anything misleading in the financial statement, there can still be 10b-5 liability. The Ninth Circuit held explicitly just the opposite. Judge Alito on the Third Circuit also held just the opposite, so there was a square conflict, and I think it will be, potentially significant decision for 10b litigation, because I think no one, I would say, probably not the plaintiffs or the defendants in the securities bar think the system is not working for the plaintiffs. 2016 was a record year for filings by securities plaintiffs firms, and also was a record year in settlements, something like $5.4 billion in settlements. If you looked at the top settlements since the enactment of the PSLRA, last year had more of the top 100 settlements than in any year since the PSLRA was enacted. So I don't think anybody thinks that the system is broken. If the court were to embrace a pure omissions liability theory, it would in effect enable plaintiffs to go after securities filings that are literally true in every respect within their four corners and not misleading by virtue of being incomplete. And to say that of the thousands of reporting requirements, you were required to say more about this issue or that issue or some other issue and impose 10b liability that way. So I do think that's going to be very interesting case. Our merits brief has already been filed. The amicus briefs, and we're getting support from the Washington Legal Foundation, are due Wednesday. It'll be very interesting to see the position that the government takes in this case, because traditionally the SEC has sought to preserve the most expansive interpretation of 10b as possible, but I think this would be quite a dramatic expansion of the implied right, and the court in Stone Ridge seemed to make pretty clear that the courts ought to get out of the business of expanding the implied right. So I think it has a little bit of resonance with the issue of disgorgement being an implied remedy. Just as the court would be, I think, very willing to look at the legitimacy of a remedy that isn't specified explicitly by Congress. I think there may be some reluctance to expand the private right to an area where there really has never been, up until recently, there really hasn't ever been 10b litigation on this issue. So that's the Leidos case, and I don't think there's anything directly coming out of Kokesh that will help us, but certainly the reticence and the concern about implied remedies and what the court should be doing with implied rights and implied causes of action, I think that's all very much at the core of what the case will be about.
Thank you, Drew. Take questions from our audience now. If you're online, please write your questions in. If you have a question here in person, please step up to the microphone and let us know who you're with and what your question is for which speaker. Yes.
Larry Ebner with Capital Appellate Advocacy. In the Bristol-Myers case, I'm concerned that the facts surrounding the lack of out-of-state plaintiffs' connection with California were so extreme that the decision still leaves much unanswered about what type of connection or how much of a connection is enough for case-specific jurisdiction. For example, what if some of the out-of-state plaintiffs had spent a few days at Disneyland and taken the pills while they were there? Would that have been enough? I'm wondering if you could comment on whether you think there'll be further litigation involving connection, which I think is just another word for minimal contacts.
I do. I think it's it's an excellent point. In some ways, my interpretation of these cases is that Justice Ginsburg in particular has been trying to rationalize personal jurisdiction doctrine to let general jurisdiction do much less work and be a true safety valve. But the price of that would be, I think, in her view, to let specific jurisdiction do a lot more work. I think Bristol-Myers was an easy case for the reason that you said. There were no contacts, but if you go back just a couple terms, there's that J.J. McIntyre case where the London company uses a U.S. distributor and there's a single sale in New Jersey, and the court was really divided over whether you could get specific jurisdiction in that case, given the sort of the relatively minimal contacts that are at issue there. And so I do think there is a gap between the facts in J.J. McIntyre and some space between the facts in J.J. McIntyre and kind of Bristol-Myers on the one hand and the actual car crash occurring on Main Street that is going to be fought over. So I don't think the specific jurisdiction playing field is completely settled. It's in some ways why I think Bristol-Myers was an easier case for them. And J.J. McIntyre, which didn't have quite the stakes, was much more difficult.
Other questions? Yes.
Mark Chenoweth with Washington Legal Foundation. I wonder if a theme of the term could be the court's retreat from judge-made rules. You mentioned SCA hygiene as an example of this. CalPERS you mentioned as an example of retreating from judge-made rule in terms of equitable tolling. And we didn't talk about the Microsoft v. Baker case, but that's another example where the judge-made sort of death knell doctrine was shown the door. Do you see that through the jurisprudence, or are there counterexamples where the court seems to be embracing judge-made rules or not?
Yeah, I think that's correct. I think that in the Kokesh case is a classic example of reluctance to endorse even a judge-made rule that's existed for a long time. I think that's certainly a theme of this court, and not just the Republican appointees. The entire court has been quite unwilling to expand implied remedies without some rigorous basis for it. The one counterexample would be the Salmon case, but I don't think which is the insider trading being kind of the ultimate implied remedy. I mean, Rule 10b-5 says nothing about insider trading. But again, I think that that's really just based on the fact that the Dirks case had already resolved this issue, essentially, and the court was not going to overrule this old case that had existed for a long time. And, certainly the court is not going to say Rule 10b-5 doesn't exist as a private cause of action after all this time. The court is going to be willing to uphold, just based on stare decisis and practice, existing remedies. But yes, I do think that there is significant reluctance to endorse judge-made rules. That's certainly a theme of this term. It's gone back several years. In the securities context, the Morrison case involving extraterritoriality, the Supreme Court wiped out decades of precedent involving when you can sue foreign companies for securities fraud, and there are many other examples as well. So I see, and with Justice Gorsuch, I certainly see no basis for thinking that this trend will reverse itself.
True. John?
I just want to add a counterexample and again urge folks, look at this this Lexmark image products case. That's applying the principle that if Congress wants to write in derogation of the common law, they better do so expressly. That was a case where the Chief Justice said to his friend writing for the en banc Federal Circuit, where you went in the wrong way, you made a misstep, you got off on the wrong foot, I think was his phrase, was in trying to read the statute. The statute doesn't cover this. Patents get exhausted by sale because people have rights to use it. So the preference for the common law, unless Congress is specific, that shines through there. And Justice Sotomayor's decision in the Life Technologies case is another, I guess, counterexample, where she says you could have something where the judges and the juries will pick what's an important factor, but I'm going to tell you, we're going to count the fact, how many components, and it's got to be more than one. A clear rule that takes power away from courts.
Any further questions from our audience? Rich?
Yeah, Richard Sam, I have a SEC-related question, but I guess it's generally to try to see what interest you think the court has in separation of powers type issues. I gather that the circuit split is developing on the issue of whether administrative law judges can act the way they do, even though they are not officially officers of the United States. I think that the D.C. Circuit yesterday was equally divided on the issue. Do you see that as an issue coming before the court next term? If so, how are they likely to address an issue like this? And do you think, generally have an interest in separation of power issues?
I've got an example. The court, in a patent case, I'm limiting myself to patent cases, but the court granted a case, Oil States Energy, which is about a program that Congress set up to get rid of bad quality patents. Congress made a finding that an awful lot of patents got out of the barn and they're sort of bad and to be rounded up and brought back into the barn. And the patent office was given a budget to hire judges to go out and hear many trials on the validity of patents on limited grounds, fairly confined, but you have non-Article III judges canceling patents. So the patent office makes a mistake issuing a patent it should have. Patent office is correcting its mistakes, and the court took that case on the question of can non-Article III judges do that? Are these property rights that are being canceled once they're issued?
In response to your question, yes, I think the court will grant cert. There's a case from the 10th Circuit, I believe, taking a contrary view of that question. It's very important. The 5-5 in Bank D.C. Circuit, makes it very interesting to the court. In terms of how they'll rule, I find intuitions in this area quite difficult for what's an officer and what's not an officer. If I had to hazard a guess, the court will say that, in fact, the ALJs are officers, and therefore that would result in reversal of the SEC's decision, which I guess is nominally in favor of the SEC because the petition review was denied by an equally divided D.C. Circuit. So I think that this will be in the court next term, which is shaping up to be a very interesting one. And I would guess the court would reverse by a fairly substantial majority, but I don't know.
And on separation of powers more generally, today the court granted a case in the New Jersey sports betting case where the express issue is whether the federal sports gaming law is commandeers state legislatures in violation of Prince versus the United States. So it is a front and center 10th Amendment case.
Adam, I wanted to give you a chance to mention the Epic Systems case, the group of arbitration cases that the court has taken for next term.
Sure, I'll just say one word about that one. So just in terms of what the issue is, a little bit of background. Lots of employers, as well as other service providers, telco providers, for instance, have standardized agreements that disputes will be resolved through arbitration, and that has to be individualized arbitration. You can't bring a class action. And so that's a very common type of agreement. When you buy a cell phone or when you start a new job at some places, you'll sign that. And so several years ago, the state of California, the California Supreme Court issued a decision called Discover Bank, basically saying that such agreements were unconscionable, that you had to be able to file class actions, and that waivers of class actions and individualized arbitration agreements were unenforceable. And then a couple years later, the Supreme Court held in a case called Concepcion 5-4 that the California unconscionability rule was preempted by the Federal Arbitration Act. And what that basically means in practice is that individualized arbitration agreements with class action waivers must be enforced, notwithstanding any contrary state law. So that brings us to a recent decision from the National Labor Relations Board during the Obama administration, which concluded that these class action waivers and employee arbitration agreements specifically violated those employees' rights to engage in concerted action under the National Labor Relations Act. So, concerted action traditionally has been understood as stuff like forming a union and striking and things like that. And in fact, Rule 23 or class actions did not even exist at the time that the NLRA was enacted. Nonetheless, the NLRB held in a bitterly divided decision with hundreds of pages of dissents that these class action waivers were unenforceable because it violated the NLRA. And this led to a lot of litigation over whether the NLRB's decision should stand. There's a circuit split, and the court took the case. So I think that in addition to the substantive issues, which are very interesting, another interesting thing that just happened is that the Solicitor General actually filed a cert petition because it was trying to enforce the NLRB's rule, and that was during the Obama administration. And then now there's a new administration, in case people haven't heard. And very dramatically, the government reversed its position, and the SG filed an amicus brief saying that now it thinks that the NLRB's rule is incorrect. But what's so odd is that it authorized the NLRB to file its own brief defending its rule. So you have the Solicitor General, which filed a petition representing the NLRB and signing that brief, and now saying it's an amicus brief on the other side of the same case, where the NLRB is going to now write a brief in support of the rule. So, people who support the unitary executive are probably rolling in their grave, or I guess in their bed if they're still alive. And, not to mention professional responsibility issues are raised when you have the filing of an amicus brief in the same case where you've already filed a brief on behalf of the same client. So, it's unclear how the court's going to deal with that, and the case also raises some pretty deep issues about Chevron deference. For instance, how does Chevron deference work when you're interpreting the NLRA, where there's no doubt that the board gets deference, but it's how the NLRA interacts with the Federal Arbitration Act, which is not a statute administered by the board. Then you have other questions of how Chevron deference works in the context of the administration reversing itself. And the other odd thing about the case is that what the board is saying is that the rules governing class actions are generated by courts. In other words, the board is saying, well, you have a right under the NLRA to file a class action, but the metes and bounds of the class action is totally governed by procedures enacted by other entities like state courts. And so if a state decides to abolish class actions, for instance, or expand them, then it can do that, and then there's just no right to file a class action. And so really the board is kind of deferring to entities outside the board in defining the scope of the supposed substantive right to file a class action. And it's just unclear how Chevron should work in that context. And especially in light of Justice Gorsuch's stated reluctance to apply Chevron, or skepticism about Chevron, and the rather intricate Chevron issues in this case, which kind of depend on exactly how you understand the justification for Chevron, I think this might lead to a very interesting decision. Although it's possible the court will just say that Chevron doesn't matter, the plain meaning of the statute goes one way or the other. But I'm suspecting there will be at least some interesting, at least separate writings on exactly how Chevron works in this context and how it relates to the justifications for Chevron.
WLF did file a brief in the Epic Systems case as well, so those of you who are interested in seeing our position on that, you can find that on our website. I want to thank you for joining us, those of you who came in person, and also those who joined us online. If you're interested in watching this again, either live, those who are online, or in person, it'll be up on our website as an archive file afterwards, and we will continue throughout the summer at WLF to be active in Supreme Court briefing and doing papers and blog posts on things, so please keep an eye on what we're up to. Thank you again. Have a nice summer.